order. Take your seat, we're moving out. So the three official ones are language for city attorney, discussion of interim appointments, continued discussion of non-disclosure agreements, and then if it's not terribly late, I just would like to get everybody's assessment on the town hall, the three town halls.
Madam Chair,
Yes, ma'am.
can you hand another copy down for Mr. Bryant? Oh, look.
Yeah. That is from, and that's the last one I've got, so.
Do you have one? Yeah.
I have one, yep. Okay, so let us begin with, I think, Laura, you're gonna probably wanna kick this off about language for, if you can define what the issue is, and who you would like to hear from, and we would go from there.
Oh, well, I propose to use the language that's in the model charter. I had given it to you all about a couple months ago. But Jim was looking into it. Recently I gave him, it happened to come up on the International Municipal Lawyers Association that other cities around the country were asking these questions. So a whole bunch of different cities sent in what they have for the attorney, city attorney. So I passed that on to him to look at.
Okay, and I know he got it, but he got it just in the last day or two, I think, too. It was voluminous.
It was.
We knew it was gonna be voluminous.
There was a lot
Last week. It's really, so it's really, he needs to really look at the
Yes.
to see if he thinks that certain things should be in there or not.
Well,
Unless he's okay with just the language from the charter.
If I may.
Yeah, please.
So I think the question really comes down, and I might be seeing a slight bias, and I'm trying not to.
Hey, you guys, this is important, hang on.
So, I think there's three things, maybe four things that you'll need to be thinking about. Is there a law department or not? There's certainly a lot of benefit to having a law department. There's a lot of efficiencies. There are things that external candidates or external lawyers who bill by the hour is costly to do. So if you have someone as a law department, and we've had a law department for close to 25 years, I would think, maybe slightly longer than that. So it's an expectation. The second part of that is whether or not there's an expectation that the law department will use external lawyers out, basically of counsel, such as firms that have expertise that are outside of the expertise of that. And if that's the case, who is the person that manages that? I think the third issue you have to think about is who does, if you have we're just going to call it, rather than we've had county attorneys, we've had general counsel, let's just say that you're your legal counsel. So the question is, who does your legal counsel report to? Does the legal counsel report to the mayor? Does it report to the administrator, which is probably not an ideal thing, because they should be probably, in my opinion, equal in that regard? Or does the attorney report to the full commission? And then the other part is, do you want to have your general counsel, or is it legal counsel? I just slipped into that.
GC.
Is that legal counsel an internal employee? And so they could be appointed, they serve indefinitely until they are retire or, asked to quit by the commission. Also, who gets to fire the attorney? Or is that attorney someone who is an external? That is someone that is an independent attorney in that regard. So through the history of Augusta, we have had Jim Wall was the county attorney for a number of years. He was followed by my law partner, Steve Shepard, for a very brief tenure, Todd Boudreau. And after that, we went into having an employee chief legal officer, and that was Gene Jessup, Chiquita Johnson, I think maybe it was Andrew McKenzie and Wayne Brown. And then on an interim basis, I have been serving as the interim general counsel, but obviously I'm still in private practice. And so the question is, do you think that that chief legal officer is better to be someone that's employed or someone that is external and has, I think there's some benefits of both, to be quite honest with you. The other question that you can ask is, should that decision be in the charter, that is, it will be external, it will be internal, or do you want to allow the commission to make that decision? And then I think the last thing that y'all raised this earlier today is, what is the experience that they should have, and should that be something that is in the charter, or is it something that you want to do by job description? Recently, they've done some advertising for, a lawyer, a general counsel. One of the things is that they must be a member of the Georgia Bar, or eligible to be a member of the Georgia Bar. So you could have someone who applies that's outside of the jurisdiction, but they may have reciprocity and they can come in and practice. Sometimes we look at how many years of municipal practice it is. And so if you do that, to a large extent, you'd be excluding local candidates, if that makes sense, by virtue of there's not a lot of lawyers in Augusta that do municipal law. So that's sometimes you want to say so many years of this and so many years of that. We get sometimes in the minutiae, we want them to be a trial attorney and things like that. That gets into some dynamics that we can talk about the advantages and disadvantages, but generally the general counsel is not trying a lot of cases, similar to the district attorney does not try a lot of cases because they're managing lawyers, they're answering questions from the commission. But there's just a lot of nuanced issues of what you think is best for the community, and how much do you want to lock in stone versus you want to allow to be adjusted by a future commission to the next round. And if I did a good job, I made a lawyer answer, which means I gave you no answers, but raised some questions for you to consider.
I will say this, that similar to what he said, you could also even say, and just make it real general in the charter, maybe generally what its duties are, or her duties are, and then if you didn't decide whether it should be an outside firm or, in-house, you could say they may designate a city attorney, you can designate a law firm as the city attorney, may, and then that gives them the option.
Some of the language they had that was in your 40 pages or 50 pages of lawyer talk.
Wasn't that much.
I think it was. So one of them was duplicate. One of the issues is it's the appointment.
Yeah.
And so does the appointment,
Yeah.
are you appointed,
Does the mayor send it to the commission and then the commission approve it? How long is it appointed?
yes, for instance, the county attorney that's in the charter, current charter, we have a county attorney in a law department and hire other lawyers. Some of that is for, the county attorney was always for a year, okay, and they were not an employee, it was very specific. So every January, you would appoint your lawyer. If you hire a lawyer, I don't think you're going to get many candidates if they're hired and they have a job, but every year they have to get their new job. So you kind of have to think about that term, and it can be for an indefinite period of time. A lot of people get into this idea of contracts and lawyers and stuff like that. I am not familiar anywhere in the state bar that says, if you hire me and you want to fire me, I still get to represent you. So, I think that's important for people to understand that you can say the lawyer's for a year, but if you say you're gone, I don't think we can sue you for breach. Maybe that you owe us the money, but you certainly can't say, I'm going to go into court for you.
Right. Georgia's not a little state. You
You can get rid
can
of,
get your attorney.
you can get rid of a lot of people
Yeah.
easily, so.
So, he's very, so even if, like he was saying, usually in most jurisdictions, what they'll do is they'll appoint a lawyer. And usually, a lot of times, that lasts for the term of whoever appointed them, or maybe if they get upset with them, it doesn't. And then the new person will come in and appoint someone else.
So they don't stipulate a time frame at all for the contract? It's
Well,
open-ended?
the contract is different than what's in here.
Okay.
Yeah, that's two different things. You're gonna have to, in the contract, I believe, I'd have to think about it, but yeah, you would have probably the actual contract with the city would have it. But it probably can be renewed. They can put in something where it can be renewed every year, so to speak.
And I see hands, but the last thing I'll point out in the Metro Atlanta area, it is frequent that the chief legal officer is an employee. I would say toward the southeast side of the state, Macon has external, Savannah has external, I believe Chatham does, and then Columbia County hires a firm. They don't have any, I think all of those have law departments excluding Columbia County. So, but if you were to go toward the Atlanta area, I think Cherokee may have a external attorney, but a lot of that is,
Because of the size.
size has a lot of it. I think it also has a lot to do with the personality of the community.
Yep, very much so.
So what that's worth. So,
You can have either, for however it suits the best for best.
and having two lawyers talk, we could go on for, we have been paid by the hour in our lifetime, so we will stop for a
We
while.
won't bill, but this isn't billable. For me.
Yeah. The thing I wanna make sure we're conscious of some things that are happening in legal right now. This goes around the realm of how we classify the person from what their qualifications are standpoint. I believe it's Florida now or I forget what school, but you have a lot of schools that are not requiring the American Bar Association to be part of the purview is over that school, which would mean if we put anything about the ABA in the charter, those schools that are opting not to be a part of the ABA, those people wouldn't be qualified, so to speak.
He's speaking more toward the Georgia, you can still be barred within the state, like the Florida bar, the Georgia bar. You can't practice unless, so that's what he was speaking to.
Right, I get that part. I meant like, as far as if we list qualifications
Right,
from
exactly, yeah.
where they went to school kind of thing.
Yeah,
You would more like
ABA
how many years of
accreditation.
experience.
yeah.
The state bar has some funky issues about, it has to come from an accredited bar, and accredited law schools, and that gets into some issues, probably close to what you're talking about from
Yeah.
Florida issues, but y'all have a good, y'all talked briefly today and in other times, maybe the job description is where you put that.
Right.
Other than they're licensed to practice law in the state or can be licensed in the state. And I think that's just understood.
And he spoke, and you're on the South Carolina border, you did speak to like sometimes, I don't know if it's ever been, I would think it wouldn't be from a different state, because if it's from a different state, they're not gonna know the law necessarily.
Especially
But,
South
yeah,
Carolina.
but, you know, in order to practice law in Georgia, for us,
Right.
you have to have a Georgia bar license. Now, you could come into the state and there's a certain way that you can do it, that for certain cases and whatnot, you can get well, I wasn't gonna say it, because I figured that, you know, it's the Latin term, that you can come in and get this certain decree that you can, or order that you can try that case, if you can practice here for that particular,
Specific.
yeah.
And then other states will
But
also
not
allow you that if you practice law for so many years,
Yeah.
another state will allow you to come into that bar. Georgia says if you have reciprocity with our state, we'll give you reciprocity there. But
Yeah,
South Carolina is the best one. because
Yes.
South Carolina won't let you go into their state, so Georgia won't let South Carolina come into our
same
state.
with Florida, same with like Illinois, California, all those, yeah. North Carolina does.
Yes.
Yeah. Well, yeah, we have talked to Angela, but while we're doing that, could you please pull up the model language?
It's right here.
Okay, good. So we'll read that to everybody in a minute. Let's answer your question first.
I personally think, for me, that there's such a concern throughout our community on every single side about accountability and everything else. I think it would work better if we went with the general counsel, especially considering the ethics and the potential for conflict. This is a small community. You only have so many lawyers. So if we went with a firm, there's gonna be overlap. You know, so having somebody that we know is ours, dedicated to us, I think that makes more sense. I think keeping the description very, very vague in the charter makes sense. License or ability to be licensed to practice law, which doesn't keep somebody from coming out of state, even if they're just across the border in South Carolina. If they're a great candidate, we want to be able to include them even if they're not licensed in Georgia right now. I do have a question as far as the hiring and firing. I'm hesitant to agree with anything, and it's nothing against the role of the mayor, but if the mayor is hiring and firing the city attorney, chances are the next mayor that comes in is going to want to replace them. And I think for consistency,
That's generally how it happens everywhere.
That's how it happens. for
That's
all
just
of them.
all over the country, that's generally how it happens.
If done by the mayor.
Yeah, if done by the mayor, because the mayor's gonna want their own person in there.
yeah, but the city attorney
But it
doesn't
could be done
represent
by
the
the
mayor.
commission.
The city attorney
Right.
represents our whole community.
The commission is always gonna have to, he can't do it summarily on his own. The commission's always gonna have to approve
Okay,
whatever he
so
does.
you're saying he chooses the final?
Yes.
Yes.
Okay, so I just wanted to make sure it's not just solely
No, no,
hiring
no,
and
no, no.
firing.
No.
Because I don't think we should be changing. I think if we've got a great attorney, let's keep them. As far as a one-year contract, I don't think we should do a one-year contract. I don't think, do we even need to put a time limit in there? Like, is that necessary?
No, I think we can make it as broad or as narrowly tapered as we want. And it depends on whether we use the word shall or may as well.
When you have a change of, I'm sorry, jumping out there. When you have a change of leadership, people are going to just choose their own. It's just par for the course. And it's not necessarily the other person was bad so much as they may not fit with the vision of that new leadership. And they should have the ability to make those adjustments.
But I thought the mayor was part of the commission now.
Yeah.
So if the mayor's part of the commission and if the general council is representing our entire community, then that's what they're focused, it shouldn't be based upon what this one person, whether it's the mayor or somebody else, wants. I just think if we're going to get good options in, and like, why would I wanna leave my law practice to become general counsel if I don't know that I'm gonna have a job once the next election comes around? There needs to be some kind of stability there. Otherwise, we're
But
not
that's why
ever
the
gonna
whole
get.
commission would have to vote on
Right,
it.
so it's not the power of one, it's the power of six. You get 5 new commissioners and a new mayor, you're probably gonna have a new term.
But in order to replace them, you'd still need those 6 votes in order to fire the last one.
Of course.
So Mr. Lewis was next, I believe.
So Chevy started saying what I was gonna say. She came all out over.
I'm
That's
sorry.
okay. Normally when you have a cabinet, when you start your position, you want the people that you relate to better. So the new mayor having his own lawyer, yes, the mayor is gonna be our spokesperson for the city. He's a commissioner, but he also gonna be in front. He's gonna conduct our meeting. So it's best to have a lawyer that he can communicate well with. And the next mayor come in, same way. Let them pick their lawyer. I don't have a problem with that because they're gonna answer to the city, they're gonna do the city work. And that's just a common practice.
Think of it this way, there's an attorney general for the United States. Obama came in and chose Holder, Eric Holder.
Yeah.
And then Biden had his, whatever, Trump came in and chose Bondi. I mean, whatever you think about either of those people, every time a president comes in, they choose their attorney general. And it's just, and I'm not saying what's right or wrong, I just want to point this out that, and also, you know, this is how, attorneys going into the position, if they accept a county attorney position or a city attorney position, people in this area of the law know that it is at the whim of who's ever in charge. You know, Democrats are gonna want Democrats, Republicans are probably gonna want Republicans, they know that, so. But they look at it, you know, I'll do it for 4 years, I'll do it for 8 years, so it just, and I'm not saying what you should do, I'm just saying, just maybe think about it that way.
So my concern, if it's going back to the commission and the commission has to vote on it anyways, then it's already taken care of. Like, I don't have a
Okay.
problem with that.
Okay.
I just, when y'all were talking at first, I was like, hold up. I thought it was, the mayor's just like, yep, I'm gonna hire this one, you know, and there's no other say from the rest of the commission. And that's all I was kind of trying to clarify.
No.
It doesn't always go back to the commission.
Macon does not, I think
Yeah.
Macon direct picks
No.
are.
The ours does.
Depends on your decision.
It can be your decision, but I mean, a lot of times it doesn't even go back.
You wanna
Because they're the
read
new mayor, they're ran under this, they have these ideas, like just like Obama had certain ideas, Trump has certain ideas. You know, they want someone in place that's gonna carry out
their vision.
their vision, like she said.
I would say that, if I may add, I think in this area of the state, there is a fair amount of longevity. You know, I think that if you make it, like, sounds like we're gonna reappoint every term of the mayor or something like that, you probably will have fewer people wanting to do. For certain people, it's, because, you know, there's not a lot of people who do government law, let's start off with that. And the other part of it is that, you know, I didn't apply for the job because I recognized that I could be eliminated and my practice would be gone. And I'm too old to start a new job. But the idea of that is you do have to kind of, there is a lot of longevity, and I think we're making it seem like there's this constant flow. It doesn't have to be. Jim Wall was here for maybe 10 years, I think.
Oh.
No, it was less than that. Sometimes it seems like they're here for a long time. I thought my law partner was here for a long time. He was here for 3 years. In fact, I think that's about history for a law. General counsel about 3 years or so. But the law firm of Holbert's been with Columbia County for decades.
Yeah.
More than 20 years.
Yeah.
So it's just, it's really how y'all want, what y'all think is the best way. If you were hiring a lawyer for yourself, how would you want that to work? What would the relationship be? And then you kind of expand it to, what if it's my company, now it's for my community. And I think that's how y'all have to look at what's the best.
And
Before we make the comments, can you just read what
Oh,
the
yeah.
model charter
So
says?
this is
'Cause
what the
that'll
model
help
charter
shape the
says.
thoughts, bring it to a head.
And you know, and also recognize it's just not the mayor that they represent. They represent the departments, they represent the council, they represent everybody.
The government.
The city council, or it could be mayor, or it could be city manager, it could be any three of those, shall appoint a city attorney together with such assistant city attorneys as may be authorized, and shall provide for the payment of such attorney or attorneys for services rendered to the city. The city attorney shall be responsible for providing for the representation and defense of the city in all litigation in which the city is a party. May be the prosecuting attorney in the municipal court, which yours would be civil court if you had it. Your office is prosecuting?
We have a separate person in this
Yeah, but
magistrate
it's,
court.
yeah. Shall attend the meetings of the council as directed, shall advise the city council, mayor, and other officers and employees of the city concerning legal aspects of the city's affairs, and shall perform such other duties as may be required by virtue of the person's position as city attorney. The city attorney is not a public official of the city and does not take an oath of office. The city attorney shall at all times be an independent contractor. A law firm, rather than an individual, may be designated as a city attorney. And the important part in there is an independent contractor, if you think about it. That goes to, you know, if they feel like they need to make, that's just strengthens it a little bit. That's what it says.
So if you were to use this kind of broad language, fundamental choice is who's going to do the appointment?
Right.
Is it the
Right.
mayor, is it the commission, or is it a manager, assuming that the whole package goes together, right? So that's kind of the A fundamental decision. And the B decision is whether or not you want to allow for the independent law firm to be counsel.
And they stipulate as may.
Yeah.
Yes.
So a
Yeah, it's
commission
not
could at
required,
any
but it's
point
a
in
man,
time,
yeah.
you're baking in flexibility on that count.
So it doesn't carve out like you have the attorney and the law department, but it still has it still provides that you can hire, you're gonna hire attorneys, and that could be in a law department, it could be in a law firm, you know, either one.
Or possibly a combination of both.
Yeah, or possibly a combination of it.
So I'm trying to follow here. Are we creating an entirely different,
No.
so are we so that's different language from what's currently in the
Yeah.
charter.
Mhm.
So are we adding to it, or are we
This would be
changing
in
it?
replace of it, but you could still have your law department with this language because it's so general.
Okay.
You separated it out. You don't have to, but you could still do it the way you had it. I mean, that's y'all's choice. That's the choice for y'all to make. Whether or not you wanna have it as it is in there, or if you wanna have something more like this.
Yeah, I'm only asking for the benefit of the
Yeah.
committee.
When I say
Because right
you, I
now,
mean
it
the
seems like
royal you
the
kind of we.
simple way to start is to look at the current language and to see what's not working. So has there been a determination that the current practice of the county, that the law department does not serve
a purpose here, that it's not saving the county money, because under the Consolidation Act, when the law department was developed, it was there, it was put there for a reason. Because I assume that the government thought that this would be the best way to save the county money. So are you looking at it from a practical standpoint in terms of what's not working? That's the reason why we're here. So if it's not working, then you're gonna look at other models to see. So has there been a study like that?
No official study, lots of personal opinions. And I don't know that we'll hear as we go around the table who thinks what, based
Well,
on their personal experiences.
Yeah, look at the current language and just go from there to make the change, because I
Except the
think
charter that
it's
we got.
confusing me.
After this factors, I'd like to explain a little bit about what Zena's mentioned.
Okay, so Sheffy was first, then Angela? Okay.
For me, I just want to make sure whichever language we go with does not set up for a long term.
Yeah.
I'll give a clear example of this, our school board. That the attorney for our school board literally has been generations of the same family.
Wow.
That does not bode well for certain things being able to move forward. So, no, I don't think we should change it over here, but I also don't, want 50 years of the same mindset, because we have to be nimble as a community, period. We have to change with the times, those things have to adjust. So whatever language we're using, they have to be nimble enough where the government is allowed to do its business without being hamstrung. I'm gonna use that word yes, by our charter.
So the school board hires a firm, right? It's a firm that handles the school board.
It's a firm, but the firm has been there and very, very, very.
And I think that's the major difference with Augusta, because Augusta specifically mandated that it has a law department, and then it has another section in the charter that says the general counsel shall oversee the law department. Yeah,
That's
so I
incorrect.
think,
That's incorrect. It's not in
so
the
they're
charter.
different. So it's not in the charter of the general counsel, but the law department is in the charter.
The law department is.
Came as a part of the consolidation.
Two different issues. Ms. Prentice, can I respond to these, or do you want to speak first? So the first off is the school board does in fact have an in-house attorney, Kim Fletcher. His last name is not Fletcher, but if you want to make it easier,
Yeah.
it's Pete's daughter. Pete is deceased, and his brother Larry and Larry's son tend to do the representation. And so while you say that you don't want necessarily generational attorneys, do think in mind that you're also taking a lot of historical knowledge away. And so, again, if you take away that knowledge, who are you going to bring someone else in, hopefully with the same amount of knowledge, because there's just only one school board in Richmond County. So you don't have the pool to pull from. And I say that's the only reason to keep someone, but it's also they do have some knowledge. The charter has three different things about attorneys. One is it says that there will be a law department, shall. The second, it says that the charter, that they may hire a county attorney. And the third is that it says that there can be other attorneys hired. And so what fundamentally happened is that when the charter was made, there was a carryover of all laws that were not repealed or inconsistent. So the county attorney was an opportunity. Jim Law continued that. Jim Law then created a law department. It took him a couple of years to do it. There was some friction on that. But the concept of general counsel did not come into the charter. It's not in the charter, but really come into place until after Todd Boudreau served in that capacity as county attorney. So there's nothing that just, so you have basically, the county can designate who their chief lawyer is. County attorney, external, general counsel, internal, or I think it's easier to say your chief legal officer. And so that's just how you, if you want to have the flexibility to have that person, that's great. If you want to designate it will be an employee or will not be an employee, you have that flexibility, but I think the model charter gives you that flexibility if you like.
Lori,
I
I'm
do
gonna
have a
piggyback
question.
on this real quick, back and forth.
I was looking up in the charter, I saw the law department for the sheriff's department. All I see right now is the county attorney power and authority to elect duties, term, compensation, and eligibility for retirement benefits, and then the next section is additional attorney's authority to employ.
I think it's 139, 151, and 152.
Yeah, that was 151.
One-
I've had to see this like
Yeah,
a dozen
139.
times in the last year.
But isn't that, 139, I thought that was under the, where's?
139 is sheriff.
Yeah, that says sheriff though.
There's a part that says that those shall be a law department.
Yeah, but I thought that was for the sheriff.
No, it's-
It's for everyone? Okay.
Yes, it's just-
Okay.
In a
Because the
bad section.
attorney.
I thought I saw it in there
It's
years, months
dragging
ago.
bad.
Yeah, that's how that tracks.
It's everything in the kitchen sink, that's what it was.
And what happened at
I thought I
the
saw it
Consolidation
before.
Act was actually the charter, the Consolidation Act. They kept all the stuff from the county
Yeah.
and the city, and they did not, like, the Consolidation Act is actually the charter that we're supposed to be, but for some reason, they jumbled in a lot of other stuff.
That is.
I was just gonna, I agree with what Zena was saying, what's broken? Like, what is,
So-
and as far as, from my perspective, the only issue is us, no offense.
I take no-
But getting, and not interim, like filling that role. So outside of filling that role, what is broken about the law department and the way that it's working right now? Because I haven't heard any concerns regarding that. As far as what Ms. Robinson was saying, I do understand what you're saying with the longevity part, but my concern would be the school board can vote them out. Like, they can vote to not vote them out, but vote to replace them. So they still retain that power, and I think the commission would still retain that power in this case, if nothing changes. So if they're really great at their job, let's not purposely push them out when we can keep them.
I think it's more of the conceptions where the attorney stuff is, how to put all that
Yeah.
together, more from an editing standpoint.
Is there general consensus that the model charter captures, Robert, I'm sorry, you have a comment here?
Yeah, I do. Whenever you get to me.
Okay, hang on one second, I was just trying to find out if we had general consensus that the model charter captures what currently exists.
Do you want me to read what's in your charter about the city attorney right now?
You could, and then maybe read the model charter one more time, because
Okay.
what we're trying to do is get to a
Right.
point of agreement.
This has nothing to do with the part about the law department, but it says for the county attorney, the board of commissioners shall have the authority to elect an attorney at law who is licensed as such, and whose duty it shall be to advise and represent the board of commissioners in all legal matters which, okay, we won't go into that. I'm being a lawyer. In all legal matters pertaining to the discharge of their official duties and to represent the interests of the county as said board of commissioners deem it proper. The term of office for said attorney shall be for 1 year, and he shall be elected by said board at its regular meeting in January of each year. Said attorney shall be compensated upon a fee base or upon a fixed monthly salary annually or other method of compensation as said board of commissioners deems to be in the best interest of the county. The county attorney shall be ineligible for membership under the existing pension or retirement laws of Richmond County. The board of commissioners is authorized and empowered to employ additional attorneys for compensation when deemed in the best interest of the county by said board of commissioners, and to pay said compensation of the county funds. Now, I do want to point out before anyone marks it out, this is one of the problems with the original charter where they just put it together, because this is all county, it doesn't talk about city, this would have to be changed. And do you want the mayor to, there's kind of checks and balances if the mayor, like, puts someone forth and then they approve it. I'm not saying you have to do that, but I'm just saying this doesn't fit because it's geared towards the county, just the county, not the consolidated government. So this doesn't even account for a mayor, basically.
Mr. Francis?
So you would have to change it.
Thank you, Madam Chair. What I was going to actually say, I hear the term going around what's working now. But what's working now may not necessarily work if we go to a different form of government. And I heard Mr. Plum, and I may begin to elaborate just a little bit, what like municipalities are doing, like Macon, those other municipalities, are they, I think you said an external form of, you say an external form of, what?
So Macon has an attorney, he's a private attorney, and they have a law department. Savannah, I think they have an attorney, and they have a law department. I believe Chatham has an attorney and a law department. Columbia County has just an external law firm, all there. When you get to the metro area, like Athens is not in the metro area, but Athens they hire external attorneys if they need them on an expertise basis, but they have a law department and they have a chief legal officer that is an employee. It's more of the southeast part of the state that has the model of a independent chief legal officer. I want to say one of the larger counties in the Atlanta market has an attorney that's hired at like a firm, but it's out, it's not an employee. But like Atlanta, it's a law firm. I mean, it's all internal. The cab is all internal. Cobb, I think it's all internal. Some of the things there's decide. I think it's some of its preference. I believe that anecdotally, when this was being done, Bob Daniel was alive. I don't know if y'all remember Bob Daniel, but Bob was in life. They weren't going to get rid of Bob Daniel. That's why we have a county attorney language. And I think the city was interested in possibly having a law department, maybe to take some of Bob's power away. But before this all occurred, I think Bob died, and Jim Wall became the county attorney. And he, from meeting one, like, when are you going to start the law department? When are you going to start the law department? Mr. Todd, who's frequently here, was one of the people going, when's going to be a law department? So he hired lawyers for the law department, but he remained independent or private attorney in that regard. Now, private attorney's a little loose because he probably spent 98% of his time doing, and Harry Revel did a lot. But what you're doing is that, can you afford to hire the talent that you need for a law department to be fully vested, or is it better to hire a firm that has firm attorneys that can do parts of it without having them fully all the time employed? Augusta's has a fairly large legal budget. To be quite honest with you, we have four. I mean, y'all haven't asked, maybe you don't care, but there's me, my law partner. We're external. We serve the role of general counsel and deputy general counsel. What we just kind of do is co-counsel. So we have 4 lawyers that are on staff, but they're obviously Zena's here, but we've got someone who's predominantly dedicated to transportation, one that's predominant to utilities, and one that is helps scoop up everything else. And then there are 3 lawyers that are positions that are unfilled. I think we got rid of one due to budget issues. So it's kind of like, it's just what works. I think it's just a dynamic issue. There's not a right, I personally don't think there's a right or wrong answer. And I'm not trying to advocate for Jim. I think I'm always afraid that's what I'm doing, but it seems that way. I have gone back and forth over the last 25 years. Should we have one? Should be general counsel? Should it be independent? And I've come back on both sides of that. I think there's a lot of this, that person is who you like. It's not necessarily the concept, if that makes sense.
It makes sense, and I guess my point I was getting ready to make, based on what you were saying, we don't know what we don't know. But when I say that you're looking at a municipality that mostly closely aligns to Augusta and what we aspire to be, if they had a concept in place for a while, it's been working, I would think it would be prudent for us to look closely towards going in that direction, maybe versus trying to figure out which way we should go. If it's been there for a while, and it's been working, it's a proven concept, I think it's something that we probably really want to look into, maybe go in that direction.
My 2 cents, I agree with that, Angela, everything that's been said around this table. I don't, my sense have gone closer than most are to the legal system, and have been around for every last city attorney we've had since 1982. And it has run fairly smoothly, I believe. With very few exceptions did it run poorly. And it was situational more than anything. So I would share the notion that we don't have to upturn the apple cart. I think the verbiage that we've had in the model charter is very close to leaving future commissions enough space to maneuver as they see fit for our city. Angela? Oh, I'm sorry, Mr. Lewis?
You go ahead, go ahead.
I just have a question as to the verbiage. If the city attorney is hired, are they not an employee, because it mentions no pension and stuff like that? Why is that treated differently than other positions?
Because it's an independent contractor,
But why are they not just an employee?
because they, in order to maintain their independence, if they are an Apple employee hired as a 1099, is that right? 1099? Basically, they're an independent contractor, it keeps all transactions at arm's length with the commission being the safety valve on behalf of the citizens. So it's kind of like our independent auditor. They're not an employee either, they're a 1099 person that is hired for the purpose of remaining at arm's length. And it's a similar concept.
Okay, and just as a reminder, following up on what Mr. Grant said, in our recommendations, we did put that there will be another charter review in 7 years.
Yep.
So if right now we think we need to stay with general counsel, but as the city grows and progresses, if they feel like it needs to change, then in 7 years or in 7 years after that, they can change it.
So, go ahead, Frank.
So I feel that we should address it now for the verbiage, because we still carry on with county. And I don't wanna leave that for 7 years to be done. I'd rather for us to address this now, and we like the formula that we have, but we just need to change the verbiage.
What I'm hearing her say is we have to change it.
No, you don't have to.
Yeah.
Well, you do have to change parts of it. You have to change parts of it.
Yeah.
You can use some of the language, but
The
it
general concept sticks, though.
the general concept sticks if you want to use that. I can
Wordsmith it
wordsmith it so
together.
it works for you. But that particular part is wrong because it only addresses
Right.
county. Yeah, that's
So,
what I'm trying to say.
so what I'm
sorry,
hearing
I wasn't
is the
there.
only question we haven't resolved is, does the mayor nominate 3 candidates? Does the mayor submit 1 name? It's done differently around the state, so that is for this body to decide this.
So,
Yeah, I
so
think-
right now, it only says that the commission elects a
Yeah.
county attorney.
Yeah, well, what she's confusing at, that's a process for hiring a department head. And that language, that particular language, I believe is found in either the open means maybe, but it's specific language that addresses hiring department heads where, you get 14 candidates and you take 3. I think that's what you're
Well,
referring
in
to.
Macon, the mayor offers 1 name and the commission votes on it.
Yeah, but that's not anything that's written in our ordinance
Right.
charter, that's
We-
what I'm talking about.
We have a blank slate as far as
Yeah.
that topic is
So
considered.
you
So
can
this is
put
what
it
I'm
in the
trying to
chart.
get consensus around. What makes sense to this body? What are your thoughts?
So if it doesn't say that, then it wouldn't say that the mayor actually puts forth.
No, but
It
it
could
only,
be the mayor, it could be the council, it could be the
Yeah.
city manager, it could be anyone.
Mm-hmm.
And you don't necessarily have to put into language, you could just say, you don't have to say the commission has to approve.
My memory is serving that each year, while there was a county attorney in that position, that there was a motion, someone made a motion to retain. It didn't always come from the mayor, the mayor or anyone else. It was just, it's akin to creating committees or something like that. Someone said, the next agenda is we need to appoint an attorney. And then someone moved the person's name, and then they voted up or down. It's like
And to your point, if the city manager just appoints and it doesn't have to go in front, if you don't want, it doesn't have to go in front of the commission. The charter language doesn't say it has to go in front of the commissioner if the mayor appoints. the commission could do it, the council could do it, the mayor could do it, the manager could do it. But to your point, if the city manager does it, think about that change. Because the city manager, it doesn't say, if the city manager says that, it doesn't, wouldn't necessarily be at the whim.
I think
I'd rather-
part of what you're looking at, this may be of some help, is that currently there are 4 people that report to the commission. And that is the administrator, the clerk of commission, the DDE or compliance person, and the lawyer.
Yeah.
And so those 4 are kind of oddly kind of like on the same level with each other. If you put the attorney below to be appointed by and fired by the administrator, it's kind of creating a little bit of dichotomy. And hired or external doesn't really matter, but you don't want, part of the concern is having someone who can threaten that person, you know, and I'm gonna fire you. Well, then I'll figure out how to make that opinion go the way you want. And so that's
Yeah.
always the problem.
Yeah.
I mean, it's,
You
you
wanna
know,
be
6
consistent with
votes,
that, right.
that happens, but it's, the question is, sometimes, if you fire me, what will I go do once I'm fired? I think that's part of something you also need to think about.
And I think you have done where the mayor appoints for the other officer, like the other city clerk and whatnot, the mayor appoints and the commission approves. And if that's the case, you're gonna want it consistent.
Yeah.
For that reason right there, you're gonna want it consistent across the board.
So for city manager, did we say that the mayor puts forth
Yeah,
3?
but I'm talking
Up
about,
to 3, I think we said.
Okay.
yeah, I think so, yeah.
So I like what Lori's saying, keeping it consistent.
And also, I just wanna put forth, I'm not advocating for one or the other, I'm just trying to give you all the different options.
I think consistent's better. There's too
I,
much.
I kind of like the consistency of the mayor can present up to 3 candidates. And of course, he'd have to be working with the commissioners anyway, so, because it would be subject to their vote.
Because like what he said, you don't want an uneven, the dichotomy would be too vast in that situation.
Yeah. Go ahead, Mr.
Checks
Checks.
and balances almost.
Thank you, thank you.
So Ms. Brill, so basically, what's in the charter right now needs to be changed to
She's not.
Augusta, Richland County, rather than just Richland County.
But you also need to think of the fact it did say, like you have for the other positions, and this is completely up to you, it didn't say, and I'll have to, I know it said it for city clerk, I have to look at how you voted on the other one, but, you know, that the mayor shall put forth 3 candidates and the commission shall approve it. However, and I can look back, I'm pretty sure the other offices you voted just say that, but I'll have to look back. If that's what you did for those, you should probably do it for this position as well.
And if we did do that, then we need to do that.
Yeah, no, I'll make it. Just managers, even when I think we did.
Well, it's fine if it's the city manager,
It's different.
because that's, city manager's different. But like for the clerk, for the attorney, what other appointed?
Compliance.
Yeah,
Yeah,
we
yeah,
said,
whoever else, you want those positions to be
everybody says
consistent.
3 candidates for manager, so that is not 2.
Right, but the city manager's a little different than these positions.
So is the magic number 3?
So
Up to 3?
Yeah.
But if that's the case and you didn't do it for the clerk, you're gonna wanna change it for that too.
I think
Discuss the clerk.
We didn't do the clerk.
Sure did.
Yeah, you've already, I thought you've already.
No,
voted
I
on
didn't
it.
do the clerk.
Okay, good.
So, question, if I may, ask a
Please.
question. So are we saying and I apologize if y'all have already discussed this, but are you saying then the city manager will be responsible for hiring department heads, et cetera? But the mayor and the commission would be, for the legal staff, would be responsible for vetting and hiring those entities?
Just general counsel.
Just the general counsel, not the clerk, not the, so that still be.
Well,
No, the
it may
clerk
be
would-
clerk, that, yeah.
It would be the clerk, general counsel, the administrative.
Well, you have a city manager now.
And,
So that would
compliance,
flex.
not compliance, the auditor.
The auditor.
Oh, that's a new position. It's gonna be fine.
Yes, that's compliance too, right?
Compliance, I think compliance is.
I don't know,
in there.
it's not like the compliance.
Compliance is,
Well, we haven't dealt with
We
compliance.
haven't dealt with
The commission.
Okay,
She's
then
covered.
compliance.
But you could, currently on that vote where to put compliance, under the current charter, it's a report to the commission, but that's y'all's decision.
You should stay that way.
I mean, just, but I think that's what y'all have to resolve
Yeah.
at the end of the day.
So now, to continue on, let me just finish this question. I heard Ms. Backus mention about 7 years you revisit the charter. So what would trigger that being revisited prior to 7 years?
The commission saying we want to do it.
The commission can change anything in the charter at any point, it just takes 8 votes.
So it's not stuck in stone. 7 years from now, we can go back and look at this one.
And 7 years is when they have to do another charter review. I think that they could actually vote to do another one sooner if they want to, or they can vote on it only to change something in the charter.
you
Can I
guys,
say something?
yes, you, go ahead, Em.
I know I'm listening, but I was also saying too. We didn't discuss changing the charter less than 7 years. We haven't discussed that.
We did.
We did vote.
We had a vote on
The
it.
charter review every 7 years.
It's like they
No,
can-
no, that's not what I'm
But
saying.
Ms. Backus said that you can change it with 8 votes
Yeah.
at any time.
It's silent.
We had,
It's actually in the charter.
Well, yeah,
Now,
the
what you
existing
voted on.
charter.
The existing, yeah,
The existing says
Yeah.
that you can change the charter
Yeah.
with 8 votes to be compliant with state law and federal law.
yeah,
That's the only time it says you can change it.
yeah. And if you want to keep that in, you have.
we have, that's my
Let me
point.
know.
We changed the name
We
of
have
Augusta
discussed
somehow.
You did.
Yes,
It's
I don't-
Augusta, it's Augusta, Georgia.
Yes, but I don't know how it got changed.
Local law.
No, it's not local law.
It was local law, sorry.
I'm just saying we have discussed it.
Yeah, but if you, like you said, it's coming up that there's certain things you haven't decided. We're not quite at the end yet. So, these type of things need to be determined. I mean, if you wanna keep that in, that 8 votes, you need 8 votes to change the
That's
language.
two-thirds.
Or we could just let it
Yeah.
go to 7 years.
Or you
Yeah.
just,
7 years.
but they have to have a charter review committee, it doesn't say they can always change it and bring it to the legislature if it's
Yes.
a rule, they can always, if it's home rule, they can still change it. It's just, you're just saying that there's gonna be a committee with citizens on it every 7 years to look at it. That doesn't mean it can't be changed.
But the charter cannot be changed currently with a
Currently.
vote of just 8
Right, currently. Now, if you wanna keep
Unless
that
it's
in, you need to tell me.
compliant, state law
So,
compliance.
Yeah.
I'm sorry, let me just make sure I'm following. Right now, the charter says with the 2/3 majority vote, that a change to the charter can be made.
It's
I-
only for the purpose of complying with state and
Federal law.
Only.
That's the only way they can change it. Which is interesting because technically, I'm not gonna get legal about it.
Let's say that we have a magistrate court. We said our magistrate court judge only has to have 1 year of practice. And that was the way we drafted it. And state law says they have to have 5 years of practice. 8 people could go back and clean it up. But to say, we want to change to say that how something may be home rule and take rid of home rule, they can't do that with 8 votes. It has to go through the legislative process. So it's not a lot of opportunities to change. It's just very technical issues that 8 can clean up messes with.
So my understanding as well, would be 8 votes, which, well, it don't matter about 8 votes, it's just state law, does it?
Exactly.
So you don't
Doesn't
need
matter.
that,
You
so
don't
why is
need
that?
it, but as Lori said, we ought to take out some bad language in this to make it clean. Let's say that we said that there's a protected class. We were talking about DD earlier today. Let's create a protected class that federal law says you can't have.
You can't do that,
Okay,
preemptive.
it's preemptive, but you have it in your charter.
Yeah,
And now it becomes a non-protected class, and it's preempted.
yeah.
Then, so we don't have people reading this and saying, I can do this, you can just say, we're gonna take it out because state law says or federal law says you can't do
Okay.
that.
Very eloquent.
Ah,
That's what we're trying
That
to
was
do.
very eloquent.
That accomplishes everything I asked.
That is very
Good.
eloquent, thank you.
A current example of that is the municipality law on gun control that's happening right now in the legislature, where the bill is saying, as a city or government, or county government, you can't dictate that people have to have more strict, storage of their firearms within your county. Because right now Savannah has it, you have to have it locked up and all that stuff. State law is saying you can't do that. So if that bill passes, Savannah's gonna have to go back and change that. I don't know if it's in the charter.
No, it's right.
Or, it's probably the word.
Yeah.
Either way, they have to comply with state law in that regard. So that's a like a current example of where I see we have to comply.
Got it.
okay, so what is the pleasure of who nominates the city attorney when a vacancy occurs? Do we,
Mayor?
mayor, do we do it up to 3 candidates?
Yes.
Okay, is that going around the table and sitting okay with everybody? Lori, you got that?
3?
Up to it.
Up to-
In nomination, up to 3.
At a time.
And then it will be subject to a vote of the commission.
Yes.
And the commission would have to vote to release the city attorney.
Is it general counsel or city attorney?
Pardon, general counsel is the word.
I think
we
for our
use.
purposes, we could call it chief legal officer
Yeah,
right
chief legal
now.
office.
Okay,
Because that way,
And you don't have city, you don't
I
have
like
county, you
that
don't have
term.
any of that.
Chief Legal Officer.
Essentially, the mayor and the commission appoint the CC.
okay. We'll put that on the agenda for the next meeting. Do you want to, while you're here, toe into the clerk concept, since we're in the same neighborhood?
Sure.
All right, so in the interest of cleaning up the issues we have not taken care of, the clerk comes into this picture as well. You had some thoughts on the matter you wanted to share with the group?
Well, I would just say, whatever you're doing for the chief legal officer, you should do for the clerk.
I agree with that.
Okay, anybody have another thought on that, or is that good?
I mean, there are things specific to the clerk's job that I'm gonna have to put in there, but I agree, that's just their job.
So can you bring language for both to the next meeting? Do we have any other outstanding ones we need to tackle?
So I'm gonna follow this with the language of three to hire fire.
Yep,
Okay.
that sounds
Way
like,
the auditor didn't.
I think we did the auditor
Yeah.
back, and it was a similar thing, I believe. Lee,
We can do that.
I don't recall if they put in how the auditor is appointed. I know it didn't, I don't think it followed this.
Macy, are you familiar with, when they did the internal auditor, because I know you looked at this recently.
This says December 4th here.
December 4th, was it three
Motion made
people,
by Lee Howe.
the mayor,
Put in the qualifications.
puts forth 3 people,
Oh, it's three.
and the council approves, or was that not the language?
Ms. Brill has the floor, please.
Can you double check?
Okay.
okay. Next
This
thing,
says substitute.
go ahead, sorry.
Eric,
Go ahead and read.
No, I'm just saying, right here, these documents, these minutes here, it says motion approved audit charter language. Motion made by Frank Field, second, approved 10-0.
Right, she's gonna look up.
Okay.
Yeah. Thank you very much for giving us the date, that's very helpful. It's very helpful.
I'm grateful to all of you for how we're batting the ball around, we're hitting different issues, but it's good that we're after consistency and simplicity, I believe. That's gonna hold us in good stead, and give the commission the flexibility we need to.
Are we able to move to interim appointment, because I do have to.
Yeah, so, we're gonna time out while Macy and Annabelle are looking at that, and this was Angela's topic, and she does have to go, so, Angela, you wanna present real quick?
So, interim appointments, right now there is a policy, where I have it. It's not in the charter, I think it's ordinance, so it's section 500.134. where it talks about, people that are in interim positions. Now, right now, we currently have 6 interim positions that are open. Finance has been an interim position, and that gentleman is now leaving. Since September of '24, he's been in that position. HDD has had an interim director since June of '25. Planning since July of '25. RCCI since this month. General counsel since August of '24. And compliance since August of '25. Previously, we had, our previous administrator was in that position from February of '22 until September of '24. If we're electing our officials and expecting the commission, and at this point, it's the commission, which it will be moving on to the manager. I don't think that we need to have people in interim positions for years upon years. We need to have something steady and solid happening in these departments. And what I also learned is, if I am a deputy and I step up and take over the interim department head, they don't fill that deputy role. So I'm doing 2 people's jobs, and that means something's gonna get lost in the shuffle. So right now, the policy as it states, it says 6 months. I think after 6 months, the administrator has to sign off on it, and after 12 months of vacancy, the commission has to sign off on it. What I would suggest is, since this is a manager, if this gets passed, it will be the city manager responsible for hiring and firing, not the commission. But I personally don't think that there should be interim positions past a year. A year is a sufficient amount of time to put it notice out for hiring. It is a sufficient amount of time for the decisions to be made, which at this point it would be by the manager. I would hope that we wouldn't have as many problems with filling positions. Obviously, of course, general counsel wouldn't fall underneath the city manager. That would be a commission thing. But I think that we need to you can't go on forever with interims. And again, nothing against Mr. Plunkett, but Mr. Plunkett, him in an interim position costs our city a lot more money than having an actual general counsel who is in a permanent position.
I will dispute you on that.
Yeah.
Well,
I will, but that's okay. That's a different debate. But the issue, I understand your
there are a
point.
lot of numbers that have been published, and I know that there's different streams, and so it kind of gets a little tangled. But I want to say June of last year, what was published was $600,000, and that was from August through June, which our last general counsel was paid just under $200 a year.
That information's incorrect.
Well, and it's hard to come by the information, and so, and especially, like I said, I do understand that there's different income streams. But either way, so much of the complaints that we hear at town halls is about the departments. And I think that one step in the right direction is us choosing to go with the city manager, where they will be in charge of hiring and firing. But also, if you always have a temporary person in these positions, then we're not actually gonna make progress.
It's easy to not be accountable.
Yeah, so, well, because how hard are you gonna work on this person? They're interim, they're just gonna step back down. And then the other problem is, there is a policy where they do get to step back down to their job after their interim position is filled. But in some cases, because it's been so long, those jobs have been filled already. And so when we ask somebody to step up, but there is no drop back down for them, that's also not fair to them.
That's true. Mr. Boucher?
So my question is, should we devise language to make interim appointments permanent after 12 months? Or do we handle that via ordinance, or does it need to be handled in charter?
That's a question for you guys too.
I think that's the personnel policy and
Yeah.
procedures manual. So that is a policy, a human resource policy. which of course the commission can vote.
And it could be the kind of thing that if you guys think that that should be the practice, that you could put in one of your recommendations.
Well, on the appointment of an interim director or interim position, at some point it needs to be reinforced with permanency, or we move on to a different candidate.
HR puts out the request for a position, where, let's say, they have fire plugs, okay? And you have an intern head of fire plugs right now, but if you don't get qualified candidates, or you don't get the approval of the commission, the intern person stays, you know, until they do get a qualified person.
Well, I have a feeling that the reason Mr. Plunkett has been in this position for so long is the city is extremely happy with his work. It's not because
I
it's...
agree with that. But
I've had a number of years of experience in positions, and I don't want this body to assume that interim relates to bad or not good. Matter of fact, I've had some interim presidents that were better than the presidents that we've had, and they were interim. You know, I mean, the Board of Regents gave us an interim president when we went through consolidation. She was out of Northern Virginia. She was exceptional, really, really good. So interim helps in places. But I think what interim lets you do is let you decide as you hunt for, if you don't get, you got somebody in a position that can handle the job. Plunkett's not staying here because he's just lazy. He's good. You know, and so we have interim people. As I was listening to the young lady this morning who was interim of compliance, I left very impressed with her ideas, her thoughts, her vision of how it should be. The first thing I was saying, why you still got the interim tag? Somebody should appoint you to full-time tag. So the thing is that I would not tie our legs in order to say no interims versus making a note, as we said in the review, about interim positions and how long they should last. But interim does not necessarily mean bad. We have a young lady at Augusta University that's serving as interim AD right now for the second time in the last 2.5 years. But guess what? She's a softball coach. But yet she's doing an exceptional job on an interim basis. Now, I do think that somebody should be able to, from the perspective of job searches and all of that, be able to put it out. When do you expect this job to be filled by a permanent person? That's a legitimate question to ask. That's a legitimate question to ask with any organization. But interim, I don't want us to think that interim is necessarily bad. Interim comes sometimes out of necessity of where you are and what you have. If you don't have nobody who can fill the position, that's qualified to fill the position, and there's somebody there who could step in interim to do the job, let them do the job, as long as it's not interfering with the function of the city.
So, and along those lines, did you already determine that this is not to be in the charter but should be in the reports?
It's not my determination to make. I will say that my advice to you, how I would do it is I would not put it in the charter.
Okay.
It could be in an ordinance. You could suggest it's in an ordinance.
Yep.
You could suggest just keep it still in the HR, I don't know, but I would not put it in the charter.
Okay. Angela?
One thing to consider is if that person that's in the interim position is not qualified to be in there permanently, then that means that they're not able to do that job to the intent that it was supposed to be filled. And we can't leave them in there for 2.5 years because it has gone on that long. And while you were talking, all I kept thinking was put a ring on it. Like eventually, put a ring on it. If you like me where I am, and I don't think interim positions are bad, put a ring on it, make it official. If the commission is happy with the job that Plunkett is doing, put a ring on it. You know what, and I'm joking, but seriously, I think it's not fair to our community because we need somebody that's permanent in that position, but I also don't think it's fair to that person that's kind of sitting there. Okay, can you take other cases? You don't know, because you don't know what you're doing in 2 months. Well, 6 months, but you know what I mean. So I think consistency is important, and if we have elected the commission to do a job, I think we should expect them to do their job and work together to get people hired.
I can give you a couple, if I may. So there's two things that, part of the thing about the interim is that what can they do about managing the department? Because they know that they're interim and people that report to them know that's not, so can you really make permanent changes while you're interim? Probably legally you can, but you may not want to. The second thing is that some of the searches are extended searches. Right now, they're going 14 months on, a CFO, and during this time, it's not out unreasonable. And so when we put up, why I would think the ordinance is a better choice, is that some positions are going to take you in excess of 12 months to find an adequate candidate. That's just one of those things. So charter things become mandatory, and then it's like, if we don't meet the charter requirement, what is the penalty or response? And so I appreciate very much what you're saying, that the interim issues are very difficult for people to manage. Mine's different than most. I mean, I'm just a lawyer. They just call me interim. I'm just a lawyer for the month,
But can you imagine if our federal government was run that way, where we have an interim this and an interim this all the time? No, but like y'all were talking about the Attorney General, he appointed this person. Okay, well, in the meantime, if that's our local government, are they gonna let them go 2.5 years with a temporary person in that position? Like, I just think that we talk about expectations of our elected officials, and I think that this is a reasonable one. I think our HR, when she came before us, she spoke very educatedly, just like the compliance director did this morning. And I think that I haven't heard of any issues with them being able to come up with candidates, except for maybe in a couple of department head positions, where they felt like maybe they needed to raise the salary and get permission to do that. But I personally feel like this is something that we need to address, because we can't expect our government to function with
I think we should do,
temporary employees.
when we're doing our report, I think we're going to go ahead and add something like what the Supreme Court does, that if somebody authors an opinion that closely mirrors yours, you'll have a parenthesis right at the head up by the masthead that says joined by XYZ members, so that it will lend emphasis and weight to an opinion. I'm going to get everybody a list before the next meeting of what I'd like to hear opinions from you about. And you can choose to not write anything, but that's going to be an important piece of the charter too. It speaks to mindset and what we thought about things. So we'll go back to Attorney Brill here, so she's got the language together to report to everybody. Thanks, Angela.
And before I give you the language, I do want to say, again, reiterate that we had asked, I think maybe a month and a half, 2 months ago, for you to get together what you would like us to, get together what you think isn't addressed in the charter, but you think maybe that they should address it in another way. Something like the interim. Because we want to put that in the report for you, and we are working on that report, so to get it at the last minute is gonna,
Mess it up.
it might prevent the report from getting done by the time you need to get it by. So please, if you do, get it into us so that we can include it. That goes for everyone. For internal auditor, you have the Office of Internal Auditor is hereby established. The Augusta Internal Auditor shall be designated through appointment by a majority vote of the Commission. The internal auditor shall serve a minimum of 2 years unless removed for cause by a vote of at least 6 members of the Commission. The internal auditor may be reappointed by a majority vote of the Commission at the end of the term of office. So it's different than what you're saying.
It does not have a who submits the names?
Nope.
Okay, how do we feel about that?
It says it's designated through an appointment by a majority vote of the commission. So it's
Six
designated by a majority vote of the commission.
Yeah, I understand the want to retain the 6-vote portion. What concerns me is that, much like the internal appointments, if somebody doesn't submit a name, you're not gonna have a vote at all.
Well, it would be
The reason
similar
for
to,
that was so qualified.
it's a bit more along the lines of an appointment to a board.
Yeah.
And so the chair would call for nominations,
Okay,
and they would go through, and they're typically recognized in the order of the nomination. And the first candidate that gets 6 votes is engaged.
okay.
So I think it would follow that process,
But,
at least
yeah,
based on what you read.
yeah, that's exactly right.
Okay,
Thank you, Marcy.
Steve had something too here.
My recall in that reading was that we wanted to be able to reappoint someone as an auditor doing good work.
You're exactly right. That's my recollection as well.
And this allows for that.
This definitely allows for that.
Okay. Do we have any other questions on that issue? Comments? Okay, let us, so
So do you want to
enshrine
have the
that.
city attorney stay as you think about that? Do you want the language for the city attorney to mimic this, or do you want it to be what you just told me?
I think city attorney ought to mirror what we're doing for the clerk,
Okay,
and I think it should be, I think that's what I heard around the table, that
Yeah, that's
up
fine.
to 3 people,
okay.
and then they would vote.
You can do it that way.
And
Yeah.
that would ensure that we actually have an
Yeah.
appointed attorney.
Yeah, I just needed
And
that clear
clerk.
for me. Thank you very much.
Okay, so the next thing we're moving along to is what Mr. Dan Funch mentioned this morning, and this was continued discussion of non-disclosure agreements. And Dan, I just flat ran out of time to call. I've got articles I've been saving on this very issue, and I had a chat yesterday with Attorney Plunkett, so he has gotten his thoughts on the matter down to a fairly tight thing. I think it's wiser before we launch into this to hear what you shared yesterday.
I don't have the actual memo in front of me, but we had someone else looking into it, but generally, under state law, the trade secrets can be protected, and basically you could have an agreement, we'll call it NDA if you want to, relative to that, and there's certain issues about tax law or tax returns in that regard. The recommendation from our open records person, the lawyers that I've spoken to in our office, is not to put NDAs into the charter, but allow that to be by ordinance, and maybe in your report, that should be considered. Mostly we see NDAs being done by authorities that have the authority to, that are enabled to be able to sign an NDA. The counties generally are not involved in a lot of the recruiting processes. I recognize in the Columbia County situation that there were a bit more, but mostly it's brought to them, and that's what the agents are appointed for. I do have concern that if you were to put a prohibition, and the Georgia Open Meetings, Open Records rules were to change, and the NDAs were allowed, do you put the community at a disadvantage because it would have to go to the General Assembly to have local legislation to change that? I think it's not the same, but it's a little akin. We have our ethics code currently is an ordinance, and it's a pretty broad ordinance in that regard, and it talks a lot about who can do what and what is allowed. I think that it would be easy to, in an ordinance situation, to add NDAs into that situation. And that would be my recommendation. It's certainly, I'm not a member of the body, but that would be my concern in that regard. And I think the wall of open records, and I've shared with Marcy, is if there's a will, there's a way to get around disclosure. I mean, it's the people that do it. You know, the laws that are out there, You're not gonna shoot someone, I'm not gonna shoot someone, why do we need a law that says it's illegal to shoot someone? Because there's other people who are gonna shoot people, if that makes sense. And, I mean, I've been involved in transactions on the business side. How do we get around that issue? And so, I appreciate the issue, and the other thing is that, is it more about the particular situation that we find problematic, or is it the overall arching issue? And the reason I'm saying that, there's an adage, and Zena's heard me say it in our office too many times, but there's an adage that says, bad cases make bad law. And so, are we trying to address transparency? Good. Is there a way to get around it? We can try. If we don't want you to do that, are we, and I don't want to use the word knee-jerk in the wrong way, are we just responding to a situation when we create a law that says that? And we have the ability to have it in ethics and in our ordinances and things like that. So my recommendation would keep it at the ordinance level and put it in your report that this is something that we, either agree to or strongly agree that we should discourage NDAs at our elected officials. That's kind of how I would come down on it.
So also to piggyback on this, most of the economic development agencies are state-enabled authorities, which a charter cannot address.
Oh.
That's the other side of the coin is, the economic development agencies are state-enabled authorities that they can sign NDAs, but the charter has no jurisdiction over the authorities because they're state-created. So, yeah, and anybody else have something you want to say, you can chime in here. But I was also going to suggest this, just in the same fashion, I just had a conversation with Dr. Jackson that spoke with us earlier. In this report we're preparing, there is nothing to stop us from you devising what you think is a more workable situation, and we'll be delighted to include that, because that's going to be published. And with name attributions, and there'll be a running list of ordinances if you want to see something like that put in, but in our case, it's somewhat futile because it's not the city signing the NDAs, it's the authorities. So it's one of these things that we don't really have anybody to hang it on that we can impact. But that's not to say we shouldn't raise the issue either. So, how about anybody else? I also have, if you're here and you have an iPhone, I can airdrop what I've been saving for you.
Okay. Can I say something?
Sure, of course.
Thank you all for considering this, because that was really my #1 goal. Was not necessarily to get my way at the end, but to make sure it's really on the table.
Yep.
It is also, as the attorney said, let's not have a knee-jerk reaction to this whole issue of data centers and kill the wrong, shoot the wrong enemy or something like that. But these NDAs have come up across our country between governments. So they're between municipal governments or county governments. And it's no longer just kind of a speculative thing. And most of it does surround. I think the more vocal people get about the data centers, the more the data center industry is interested in being as discreet as possible.
Absolutely.
But anyway, so thank you for your consideration, and I appreciate the opening, and I will try and think about what I could maybe include in a report or a comment or something.
I think I've got about 4 that you're going to love.
Oh,
And
okay,
they're
I'll
lengthy,
take
but
3.
I think you'll be very excited about it.
Okay, thank you.
You bet. All right, finally, we talked earlier today, we've committed to 3 town halls. I want to make sure I'm understanding from everybody in this room what I want to put my concerns out there that Frank, God bless him, reined me in on, saved me from myself yet again. But I also would like to have an understanding of what we want out of these town halls. My concerns that I would have raised, I think it's legal to talk about it in a working session,
Yeah, normally have
Appropriate?
both, yeah.
Okay, so what I would have said, it, well, amounts to this. One is, what I don't wanna do in a town hall is open the door such that people feel they're gonna spit it out and raise this as a concern, and that we've decided it, we don't wanna change it, and then we've boxed ourselves in. I think if this meets with this group's sensibilities, a smarter way to do it, now that we are down to the very last decisions, would be to work as a team to go ahead and devise a real brief description of the process, all the issues that we undertook, the changes that we have made decisions on, and why we made those changes, why we voted the way we did. Explain it to people, and if it would be wise to go ahead and take subject matter experts even from the team to address some of these issues. But give ourselves, say, a 30 to 40 minute presentation on those things, and then say, what questions can we answer for you? Frank and Sheffy were talking earlier and said that what we would want to do is go ahead and limit how many questions we were going to take.
Can we get the questions in advance?
You could. Right, well, that's another thing, that happens in some meetings. And we could pick 15, 10 questions, whatever we want out of that, but,
We need to be
do
able to satisfy
comment cards, number of questions, keep their, questions to 2 minutes or less. And another thing we have to define on the front end is what belongs in a charter versus ordinance, because that eliminates a lot of questions right there. So what I'm trying to get a sense of, if you guys would all chime in, what you think we want out of these town halls.
Well, I mean, for me, I'm not sure if it's, I'm not sure if it's effective if we go in immediately telling the public how many questions they can ask. The last time we had a public sanctioned meeting was, if I remember, it was like right before we went to the summer, when the committee was formed.
We
So
have
I think it was somewhere
one-
time in the summer.
Yeah.
But I know there's a lot of
End of
ground that's
July,
been covered. But yeah, I probably would stay away from limiting the amount of questions that can be asked. One thing that I would possibly encourage is probably have some type of moderator there.
Yep.
That can basically get us back on track if we end up having someone that keeps asking the same question.
So here's the problem with that, we've had many people that have been nominated to act as moderators, and they can't come because they're TV announcers and they're in the middle of their shows in the beginning. So I'm gonna need some help with that.
Yeah. I
I am trying to get this accomplished the first 2 weeks of February for other reasons, because we've got time blocks that are gonna get real problematic. If you would tonight, I'm certainly welcoming moderator help.
So, to your point,
And
Eric,
there's 3 of them, so.
to your point, Eric, I think if we do a good job at the beginning, the 40-minute presentation, you eliminate a lot of unnecessary questions and unnecessary conversation. I think you give the information that we're trying to project to the people. They can really see it and understand it, and I don't think they'll bring up questions that are not pertinent. And the second thing, we also gonna have out there perform cards that they can fill out if they don't get a chance to talk. That way we can fill them out and pass it in, so we will have their thoughts. I think we can keep them, I'm not trying to shorten it, but I don't wanna have it all day, all night long either.
Yeah, I'm not opposed to what you're saying. I'm just saying we shouldn't come in saying that there's a limit to questions. That's it. But everything else what you said, I think that you would definitely probably coil a lot of questions if we do an initial presentation, so that way they have some background to refer back to. So.
Madam Chair,
Sure.
I think we need to provide a synopsis of what we have done when we go to these open sessions, if you will. And I know we have a budget, but we may need to have copies for the people to come in and read and take home and look at, so they may have a better understanding. And I think that would cut down on the questions also if they have it in front of them and can read it. Former government, audit, ethics, explain quickly, concisely why we did this, what it entails, and give it to the public that way as they come in the door, and that way,
QR codes for each section,
yeah.
if somebody has
Well,
access to them.
you know,
I think
at
Coach
the,
has been saying forever, we need to put this in the water bills. We'll have a chance to do that in the spring. I think that's
at the meetings
still
that I attended, one of the biggest complaints that I heard was, these people, they can't communicate, they don't know anything, they don't know what's going on, they don't know how, about the meetings, they don't know what we've done, they don't know how to get to the data. Well, let me tell you, everybody in that place had a cell phone. And if you want to communicate with these people, all you've got to do is pick one of them out, get on Facebook and say something bad about them in 30 minutes.
What
They'll all
people
know.
referring to?
I'm talking about the people that came to these meetings. What we heard was that most of the constituents in South Augusta can't get to the meetings. They don't have transportation. They don't have a way to communicate and get the information, necessary information. And I'm sorry, I just don't agree with that at all.
One of the chief complaints I heard at one of the town hall meetings was they want the city to build grocery stores, they want the city to build restaurants, they want the city to build bars. That's not what we
In the
do.
charter.
That's not in the charter.
Well, I guess that's where, Mr. Lewis was just mentioning about the education piece in the beginning of it. Go
That's
a
why I
long
think a
ways.
synopsis of what we have recommended. Give them out when they come in, have them, hopefully while we go over what they have in their hands, we'll help explain and maybe reduce some of the questions where people really don't understand what we have done.
So let me ask the young whippersnappers that understand the technology that I do not. Isn't there not a way that on a phone, everybody knows how to do texts, even my 93-year-old friends? Is it possible to tackle one of these 5-digit codes to be dedicated to a specific chunk of the charter? And they could go and access links that if they wanted to research it better? You know what I'm talking about? Text 50505 for information on the ethics ordinance.
We just said that, but,
Hey, that's your answer, right? Say it again.
Okay.
Sure, we can handle that.
There you go.
Whoa! All right, so who do I have to talk to get permission to pick on you guys?
I'll start with Jeff.
Joe?
Jeff Lewis.
Jeff, okay.
No
Perfect.
problem.
Great last name.
Great idea.
What about a media outlet, town hall? where
Yes.
Call-ins could ask questions.
I think that's a great idea, and I've talked to 2 so far, WJVF and WRDW. I think it ought to be thrown open to all of the outlets, so nobody can say we picked and chose winners and
Correct.
losers.
Yep.
So I think that's another idea we're gonna follow up on. Coach?
It might be some guys that have retired media people that might can fit it in their schedule. One that comes to mind is, of course, Richard Rogers of WRDW and some others that maybe we can think through that might provide that type of neutral, you know.
Do you have a personal contact with him? Can you just ask him about this in the first 2 weeks in February, because I understand he says he's gonna turn me down, because I know him, he knows me, but probably not as well as you know. So that would be great. We'll talk about that in the next day or two and see what we can line up. And now, is everybody okay with 6 to 8 for the timing for these meetings? Is that enough time?
yeah, I think
Yes. Okay.
Well, if the media outlet choice is an option, then maybe it's earlier in the day. That would have to do with the timing of the media outlets.
Right. Accessibility.
well, when you say earlier in the day, I mean, what are we talking about? Because this defeats the whole purpose that we're gonna be doing it while folks are at work. So I think 6 to 8 is a good time frame for that, yeah.
I mean, there's just as many people working from 6 to 8 as there are 8 to 5. Restaurant workers, bar workers.
So maybe we talk to them right up front and say, we would like you to host this if it's possible, you know, a 30-minute sit down, blah, blah, blah. And then we'll post it to YouTube where somebody could access it, right? Yeah, well, you guys know how to do that too, right? Mars does.
Hey, say it again.
I know how to do it.
So there's a few organizational things we need to figure out there. I'm sorry.
One of the things, I think someone mentioned it earlier, I don't want these town halls, 2 hours, turn into 75% of the stuff that we talk about.
Yeah.
Is audience.
Ordinance, yeah.
Or policy related versus charter related. So it's gonna be very important in our presentation.
Yes.
And whoever is emceeing or facilitating the meeting, have some understanding that can pull us back in and
Maybe
someone
we
can
need
say,
a sign that says ordinance.
I think our intern
Charter.
Karen's gonna be great for that.
Big sign.
because see, that's where we get off the rails.
Yeah.
Because we get into ordinance and policy, and it takes 10 or 15 minutes of your time, and then somebody says, well, is this really related to charter or not related to charter? I think what we need to provide to the public is what has occurred, and these are the 7 or 8 things, and I think Carl Vincent has already provided us some of that outline. But these are the things that we've dealt with, these are the things we've talked. These are the things we got rid of because we didn't need it. These are the things we left alone and we're going to retain, you know. And these are the new things. And the new things are about 6 or 7 new additions of things that we're providing here. And that's the biggest problem that comes with town halls is because a lot of the people attending town halls come with an agenda that has nothing to do with charter review, you know, and so I think that is important that we do. And the other thing is that let's just be candid here, is that the thing that we've tried to do from the very beginning is not to make this a political football where people can get on sides of the fence, Republican, Democrat, black, white, whatever, and just being able to say, our job has been to help provide Augusta, Georgia with the best government that we can possibly have, because we have not been satisfied with our current government. And based on that, I think this committee has taken that charge and they've done that. They've provided, dealt with things, some tough issues, had some tough conversations. We don't always agree. We can agree to disagree. That's cool. But at the bottom line, I think what we're saying, we think this is in the best interest of the city. And once it gets out there and it goes to a vote and all that, there'll be plenty of discussion about all of those things.
Right.
And so I just, if we're going to do them, let's be efficient, let's be timely, and let's make sure when we walk in the door, we know what's going on. Carl Vincent did a great job early on in providing the framework. I think they can do that now based on what we've already accomplished and what we've already done.
And can I just piggyback on those comments? Coach, I had a discussion earlier with a member who's now absent, so I won't identify. But I was told by this individual that there are large swaths of people who've already decided no is their vote on this charter change. So one of the reasons why I voted in the affirmative to have these meetings is hopefully to change that mindset. We need to pass this at all expense.
Madam Chair, I think we need to also make sure when we go to these town halls, it's stated right up front what our purpose is for being there. Knowing that our purpose is not looking for an outcome that will come back from the audience, that will cause us to come back and rewrite what's already been written. That's a done deal. And I think from that, I think some of the stuff we're going to hear right off the bat, well, why are we here? If we can't, if you're not going to accept our input, I think, quite candidly, I think you're going to hear a lot of that. So just be prepared.
Yeah.
Have to be prepared to answer that based on the reasons that they are.
Oh.
Okay.
Boy, Plunkett has something.
This is something that y'all mentioned during the first meeting and a couple of times this thing. You are subject to, I'm just gonna say it's state ethics laws, and that may be campaign issues. But the short answer is, you cannot go out and advocate for this thing to be passed,
That's right.
okay? That's
Can't do
a
that.
big no-no. You can be sued for it, okay? You can't contribute money to the chamber if they have a fund to do this. You can educate all day long, but you can't say, you should vote yes, or you should vote no. That's just, that's probably didn't tell you when you signed up, but that's just one of those things. So, I'll mention this closer to the report
I
coming
wanna
out
know
of the
who
referendum.
voted against letting us in.
But it's just really problematic. That's why you'll see, like a SPLOST, they'll go out and they'll tell you, these are the good things we're gonna do if this passes. But they never tell you,
Vote
you need
yes.
to vote yes, okay? And y'all said it during the meeting, if we put all this time in it, it'd be such a waste of our time. We need to get this passed. Well, that starts being slightly more advocating and less educating, okay? You can be persuasive, that there's nothing wrong with that, but you can say why it's good, you don't always have to say why it was bad. But you be very careful of that. Just
Thank you.
we're getting into this.
Time to
I talked about
digest that.
YouTubing, stuff like that. We sure don't want you to say, and go out and vote yes at the end of that thing. And it's a permanent record that you did it. So just be very careful of that, okay?
That's good.
It's gonna pass probably regardless, but don't give someone a chance to challenge it, okay?
Good to know.
That's good. Thank you.
Very good.
Well, on that note, in reference to what Attorney Plunkett said about don't give someone a reason to challenge, I mean, to go into the meeting and have the notion that everything that we've done is set in stone, we shouldn't do that, you know. Yes, we've made a lot of groundway here and made decisions and stuff, but to come in and tell the community, like, hey, we're just updating you, and that's all it is, you're automatically cutting off lines of communication with the community. So I just wouldn't start off.
I think after I get to meet with Mr. Lewis tomorrow, to see what is and is not possible, we'll immediately start mapping this out. And this whole team is gonna probably have to be pretty hands-on with this. Right down to maybe a dry run, where you shoot bullets at what's gonna be said. Because I agree with everything I've heard. If we don't have the liberty of failing or messing it up. And I think there should be multiple speakers. It should not be big mouth all the time. But this has been a very productive afternoon, I believe. We've certainly got a lot of good
And with
information.
that statement, Marcy, I agree with you. It should be one speaker, but whoever speaks, it'd be one voice. We say the same thing. Because we've already stood in this 8 months or so, voting on the same thing. We came to agreement. So it should be a different story. Agree?
Great.
So,
Well, I think what we do is what Frank just said, Mr. Lewis just said, we stand behind our report.
Yep.
That's the bottom line. We're a committee to review the charter. We're gonna give out a report on this, and we stand behind it, what we do. And there might be certain parts of it that I as an individual didn't agree on, but that's not the big picture. You know, the big picture is that we support our document. We used our consultants. We feel good about the advice that we received and how we were going about it, and we moved on. But I thank you, Mr. Plunkett, because I think for sure we can't go out there with the posture that we got this thing passed.
Oh, yes.
For me personally, I think we put it on the street, put it on a vote right now, it's gonna pass overwhelmingly, it's gonna pass.
I think so.
So I just wanted to kind of note a couple of things, just to keep them on your mind's eye. In the public policy world, we talk about windows of opportunity, and we don't want to miss our windows of opportunity either. And so, while I think all of these things are important, and we're going to do all we can to get this done as quickly as we can, we want to try as much as possible to hit the windows that are open, when they're open. And so, just kind of keeping that on your kind of horizon, that there may be times where we have to, try and make some decisions quickly.
Yes.
Yeah, so we can hit a window that opens up for us. But at the same time,
We're gonna have to call meetings to quickly turn what you're preparing to endorse it, so that can be put to rest and we can put the next 3 blocks.
yeah, but at the same time, that doesn't mean that we shouldn't do our due diligence and carefully go through things.
Right.
And so, the committee needs to take its role, continue to take its role seriously as it has. But I also I want to make sure that if there's a window that opens that allows us to do this and to hit an opportunity, I want to make sure we're there and able to take it.
All right, so Clint and I have a request that if you by the cadence call on Monday are able to identify holes that we're going to need, because folks, I hate to tell you this, we're getting down to the bare bones here with what is left to be decided. And these are little things here and there that will only become apparent as Lori is writing. So we're gonna have to decide, do we gather to make 2 decisions, or do we batch them? You guys will have to tell us how you wanna do that, because that's really,
Yeah, and I do want to say, to follow up on what Rex said, when we hand you the document, you need to take time to read it. Because it's not insult to any stretch. I'm saying that I could have missed something.
sure.
That's why I'm saying, I could have missed something and put something in there perhaps that you wanted a different way and you voted a different way, but for some reason, something happened. So I need you to read the document when you get it and not just rubber stamp it to make sure it is how you voted. And just put that out there.
Yep. Sounds great.
That was not an insult to you.
Like this.
That was to check me.
All right, is there anything else this body needs to take up today?
We talked about 140 and what you have you.
Yes, we have not
You
talked
say
about
gonna bring language back on that, right? I thought.
So,
Because they said in the review.
We didn't move to pass it.
no, I do wanna bring this up, and thank you for bringing this back up. Today we had an agenda item, we thought we were going to go ahead and approve what was decided at the last work session. Sheffy came in and said, eliminate 2 sentences, we're good to go. So today, a good bit of what was presented today, and it's handed out with that language, begins to get repetitive, because one of the reasons I stopped in their office is to say, I don't want to hurt your feelings, folks, but you do realize that our approach to this charter has been not to restate what is already covered in state and federal law, which 98% of what you put on your piece of paper expands upon. So what
It's redundant.
it becomes redundant. So I guess the question is there, and it's too bad Sheffy's not here, because she's the one that can be raising the issues, but
Well, why can't we go ahead and vote then, if that's what we feel that we're on the floor?
Well, I think there was consensus with some absent members that it needed further discussion, and for the sake of
Okay.
agreement, along with that.
This is language under consideration.
yes.
If I may, in this language, it's the attachment 1.
Uh-huh.
There's a phrase that says that we will give preferential consideration. Preferential has a lot of connotations and legal ramifications. I did check with our procurement director while we were talking, and he is comfortable with, I had suggested, additional considerations. And so we do that currently. There's some extra points in scoring for local already. And so what we may suggest is that I give an additional consideration in the procurement process, so that it's getting the same, I think, concept without taking a word that may have more than what we bid off. We don't want to do that.
I like that.
So,
So substitute the word,
it would be, instead of preferential, use the word additional, and then add at the end of the sentence, in the process, in the procurement process.
But this is what we looked at in the first section, the last time.
It's, I just, when you're, sometimes, more you understand this, you'll look at a document, you read it multiple times, it's perfectly fine, you put it away, you look at it again, you go, oh my God, how did that slip through? And so, I'm not saying this is that one of those things, but you kind of look at it and go, and it, sometimes you just have an uneasy feeling about words sometimes. So if y'all are comfortable with that, I would suggest that change.
so I believe Dr. Jackson understood what I was saying to her, that I could have done a better job explaining to her in the first place, you know, what we were needing from them, but that in all likelihood, we were probably gonna stick with what we had in the first place, because it is generic enough, and yet it still says what we need it to. If everybody around this table here thinks additional, as Jim had suggested, over the word preferential, I propose we add that to the agenda next meeting and vote it in one way or the other.
So let me ask you a question.
Sure.
I know, if I remember, Ms. Backus was asking questions about the citizen advisory board.
Yes.
So I don't know, now I can't remember exactly what she had asked for feedback on, but
She wanted to know if it was still covered, and the answer to that was the Small Business Administration, it dealt more with DBE contractors and not with the totality of the department.
right.
I propose that we put this in the commission's lap rather than necessarily in the charter,
Yeah.
and utilize the word may instead of shall, because there's a lot more to that. And again, that we would be preempting a manager who might have different thoughts on this if we assumptively decided to retain what we've got right now.
Now, how do we feel about C? Because I thought that Dr. Jackson had made a good point in reference to including language in there about the EEO coordinator as well. Assistant Director of Compliance along with EEO coordinator shall develop.
Just right here in the first sentence of A.
About A, what did you just say?
It says federal and state EEO guidelines and procedures.
State and federal EEO guidelines and procedures, which are basically sentence 2 and all of that.
She
Okay.
just had an interesting conversation, I think is gonna bear fruit, just because they are already thinking the way some of our members are thinking in terms of, we shouldn't have any silos. If you're going to have a
Yeah.
compliance officer, it ought to be across the board,
Right.
equally applied.
Well, that was my question, because I never did hear anything back from you all, but when she mentioned, she really caught my attention when she mentioned about having, I guess, jurisdiction across the entire city government when it comes to compliance. And so, I know we were saying, I think there was discussion about that might be an ordinance thing,
Well, the state law.
or state law. But I mean, when we say state law, but it's not, she just told us that that's not what's been happening. That they don't have the practices that are what's been going on here. And when she also caught my interest when she mentioned about grants. Because we also
Oh,
know
that's
HUD
a big
has,
one.
yes. So when we say things are an ordinance issue, it always gets me, because who's enforcing those
Who's policing
issues?
the
Yes.
commission is, but they're
Yes.
willfully not addressing
She definitely needs to be,
in the report.
well, she needs to have review capabilities on any federal grant.
Yeah,
Because they're so narrow and so many restrictions, and you can't depend on the departments to follow all
So-
of it.
Right, and this is the reason why I thought that it should be in the charter, because it's mandated. Because when we start talking about things being enforced by the commission, well, we understand that we have elections every 4 years. And so a lot of this stuff falls by the wayside. That's why typically when you look at planning and development, when they're passing different things, a lot of times developers or whoever has put together a plan, they've gotten denied years ago, but they'll pull it and push that same plan again when there's different commissioners on the board that had no idea that this came through. So that was the only reason why I thought that it should possibly be in the charter, but again, I know you are the subject matter experts on that.
Why don't we put that
Well,
on
you
Monday's
gotta-
cadence meeting? You guys will have time to kind of sit through and figure the angles, and then Coach, you and I should probably talk over the weekend, to get our stuff together too. But yes, I think those are all excellent points, and I felt even more strongly that way after I talked to her between these two meetings. So,
And Madam Chair, also, you have to, I don't know if you mentioned this to her or not, or she expounded on the part of what's covered on her department versus what's part of HR. Because I know she said there was, some stuff is being covered by HR.
yeah, that I don't know, but I'll go check with her tomorrow on that.
Well, maybe that should be included in the job description.
Compliance,
Sections.
chief compliance officer.
Or just make that a manager's functionality.
Okay. But that, we can't mandate that in the charter, is it?
The job description, no.
Yeah, okay. All right, well, let's do this. Let me segregate out, tease out what portions HR is doing. I can tell you from just having talked to her again, she's doing, American Disabilities.
American
DBE.
Disabilities Act.
Yep. DBE functions, disadvantaged business enterprise, EEO, minority and women business enterprises, oversight of goals and their monitoring. They have no real teeth to enforce anything or require. For instance, I can tell you, we're in a heap of trouble right now because of grant assurances at the federal level. And it's not just one or two departments, it's pretty well. So that's a pretty big structural thing that needs to be done. Again, you guys may come back and say, report. But I think it's a little bigger than it was in my mind when we put this on the agenda.
Yeah, well, I mean, we just figure out some kind of way that these other departments are mandated to talk to the compliance department, so that way they're tracking, grant money that's been given
Yep.
and things of that sort.
And that almost that's like a combination between ethics and audit too, actually.
Yeah.
You can't assure that kind of behavior unless you get rid of the silos and make it, you're right.
Well, Madam Chair, that also is part of training requirement as well.
Yep.
Because when they do that training, when they do that individual training, especially for directors and deputies, they should have to sign saying they have been at least attended the training as part of their evaluation piece as well.
But then, let's just think about it. When you got, going back to Ms. Becker's question, you got all these freaking interim directors, you've lost your continuity.
Yeah.
I mean, you think about the finance director that just left. I mean, how many decades was he here? And that,
Well,
a good chunk of that.
As interim, he's only been here for what?
Well, he's been here in the
He was
department as
working
deputy though.
under Donald Williams for years.
Yeah, so that's what I'm talking about. You got your continuity piece.
Are you suggesting that he's resigning because his title is interim?
No, I'm not suggesting any of that. What I'm saying is that when we have these folks that are leaving, the information leaves with them. And so where do we have it documented at? I mean, I don't know if there's some type of continuity book. And that's why I mentioned about the compliance being written somewhere. So that way folks can refer back, oh yeah, this is something that should be done. So that's what I'm saying, checks and balances. I'm not getting into the minutia about what went on, but I'm just talking about the information is leaving the organization.
So capturing the institution.
Yeah, sure, because they know what the typical process we're going on.
Transfer.
Succession planning,
Yeah.
That's why payroll was a nightmare.
Oh, yeah.
After Miss Betty retired, because you had one person in the same position.
And maybe that's
Same
another
problem at the clerk's
conversation
office, too.
or something
Yeah,
else.
because they need to audit
The
things.
last lady retired out of Kirk's clerk's office was only there 60 years. I don't understand.
Yeah. All right,
Compliance.
the meeting adjourned.